The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your frequently infrequent podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by IJ Senior Attorney Bob McNamara, as well as IJ Attorney Andrew Ward. Bob, let's kick things off in the Fourth Circuit.
Let's, John. So we start out in the Fourth Circuit with Overby v. Mayor and City Council of Baltimore. And Ms. Overby, several years ago, was involved in an altercation with the police in which some things were said, some blows were thrown, and it resulted in a lawsuit she filed against the City of Baltimore alleging police misconduct. And the City of Baltimore settled that lawsuit, but as apparently it does in every police misconduct lawsuit, it insisted that Ms. Overby, as a condition of settlement, sign a non-disparagement clause where she couldn't say bad things about the conduct of Baltimore law enforcement. As things do, this resulted in some discussion on the internet, and in a fit of what was perhaps poor judgment, Ms. Overby decided to participate in the comment section, responding to some commenters who said that she perhaps had behaved badly. She wanted to defend herself. The City of Baltimore took exception to this and insisted that she was in violation of the non-disparagement clause by posting things on the interwebs and demanded some of their settlement money back. Ms. Overby sued, and she was joined eventually by a local newspaper, of which I know John is a big fan, called the Baltimore Brew. The Baltimore Brew said, hey, we like to write about police brutality. We like to write about police misconduct. And every time Baltimore gets sued, they insert one of these non-disparagement clauses in their settlements. And that violates our First Amendment right to talk to these people. So Ms. Overby said it violated her First Amendment rights to have this clause in her settlement, and the Baltimore Brew more broadly wanted to challenge just Baltimore's policy of demanding these. And I guess this is the point where I should disclose a little bit of a rooting interest, as opposed to the usual dispassionate commentary you get here at Short Circuit. IJ has a somewhat analogous case in the district court in Washington, D.C., where we're challenging an analogous policy the SEC has. The SEC for decades has had a policy of refusing to settle any administrative or civil law enforcement action it brings unless the defendant agrees to a global gag order under which they can never challenge the veracity of any of the SEC's allegations. So we're litigating that on a similar First Amendment theory, though our clients, though the speakers in our case are in a weaker position because they're actually defendants in a criminal action. But what the Fourth Circuit tells us over a dissent is that the First Amendment prohibits these kinds of agreements. There's an overwhelming First Amendment interest in public debate about police misconduct, and the government therefore cannot enter into agreements with police misconduct plaintiffs where as a condition of settling a lawsuit, they have to waive their right to say critical things about police misconduct, that there's an overwhelming First Amendment interest in having these public debates, and we can't let government entities buy their way out of these debates. And so Ms. Overby should prevail on her First Amendment claim. And also separately, the Baltimore Brew has First Amendment standing to allege that it wants to talk to people and that Baltimore is essentially handing out cash to silence people and using its governmental powers to interfere with the Baltimore Brew's reporting.
Andrew?
I was taken by how strongly the majority criticized Baltimore for this practice. You know, they're calling this hush money, that there's just an overwhelming interest in the press being able to take a look at how the police is behaving, which it matters. I mean, what the plaintiff here is accusing them of is that she called 911, and when the cops showed up, they beat her, they tased her, and then they arrested her, and the majority thinks that people need to be able to find out about that.
So I got an email from a supporter who said, listen, she signed an agreement. She signed a contract waiving her right to speak, and Baltimore's done nothing wrong here.
No, I mean, I think that is a lot of people's position on this case, and that's certainly the position of the dissent. The dissent says, look, this is just a contract. She had a claim for damages, and she could have settled that claim for less money and not had a gag order. Instead, she decided to settle it for more money and essentially sell her right to free speech, and that's great. And there's a certain sense in which that's kind of the libertarian answer, right? It allows people to contract away their constitutional rights. But I think
this is what some nerd jumps in here and says this is a Pareto improvement.
Some nerd, some hypothetical nerd who would say such a thing on a podcast that will live forever, Andrew Ward. But I think that the thing that actually the Fourth Circuit doesn't ever explicitly invoke, but the thing that's lurking underneath everything here is something called the unconstitutional conditions doctrine. The unconstitutional conditions doctrine says the government can't demand that you hand over your fundamental constitutional rights in exchange for the government's exercise of its power in certain circumstances. And so I think there's a spectrum here. If the city of Baltimore hired a PR firm and said, we want to hire you to make the police look good, I think it would be difficult to say that the First Amendment prohibits that contract and that the PR firm has an absolute constitutional right to take Baltimore's money and run exactly the opposite message. But at the far end of the spectrum, it would be obviously unconstitutional if Baltimore prosecutors started saying, hey, we might prosecute you for that DUI, but we'll let everything go just as long as you make sure to donate to the mayor's reelection campaign, or just as long as you make sure to vote for the Democrats next time, or just as long as you make sure not to say anything mean about the cops who arrested you. That the government trading its kind of sovereign power to punish you for violating the law in exchange for your First Amendment rights, even though in a certain sense that's a contract. It's not the sort of voluntary contract that we traditionally respect as a contract, and it's not the use of governmental power in a way that's appropriate. We don't give the government the power to enforce laws and to have all of the overwhelming powers that government has so that it can then trade those powers away in exchange for silencing speech that makes it look bad. That's not the purpose of those powers, and government can't trade them for that. This case is, I think in all candor, a closer version of that. This woman was a plaintiff. She had sort of more leverage than certainly a criminal defendant would in the unconstitutional conditions context. But I think really what the majority is saying is what the government is doing is taking the settlement it would have reached anyway. This claim had a certain amount of merit. There was a certain risk that a jury was going to award Ms. Overby X dollars, and it was grafting onto that settlement a gag order that served no purpose beyond making sure the government looked good, and letting the government exercise its fundamental sovereign powers for the sole purpose of making itself look good and preventing people from making it look bad is exactly the sort of abuse of government power that I think we should be most worried about, even if the government wants to style it as an agreement. The question is that a voluntary agreement, and is the thing the government's trading away something the government's allowed to trade away in exchange for silencing political speech?
Law enforcement shouldn't be in charge of deciding who gets to criticize law enforcement. Seems like it makes a lot of sense to me. One of the other things that I liked about this opinion, I'm always on the hunt for just bad legal arguments because I think they're funny. And my favorite one from this case is where the government said, well, these waivers don't matter. You get to file public documents in a lawsuit. So isn't that more than enough for you or for the press to tell your story? What else could you possibly say? Which is kind of suspicious because it's a real question why they would bother to go through having a gag order provision in these contracts if they didn't think that people had anything else to say.
Though that is the classic kind of First Amendment defendant move is, look at all the other things you can say. You could sing a song. You could do a dance. You just can't talk on this particular topic where we've decided to silence you. And so what could the First Amendment have to say about that when you can sing the entirety of the musical Oklahoma from start to finish? And that is, I think rightly that's not an argument that is embraced by the dissent. It's an argument that is given pretty short shrift by the majority because there's no question that the subject of this contract is silencing Ms. Overby on a topic that the city of Baltimore thinks would be politically disadvantageous to it.
How is this case stronger or weaker than our case against the SEC?
So I do think this is different from IJ's case against the SEC, opposing counsel if you're listening, in a couple of ways. One is the procedural posture in which this contract was extracted. Ms. Overby is a plaintiff. She has a claim for money damages. And if she doesn't want to be involved in the lawsuit anymore, she can just drop her lawsuit against the police. There's nothing stopping her from walking away. And so the government holds fewer cards than it holds in, as for example, an SEC civil enforcement case where they allege that you have violated 5 different aspects of the securities code. You have no way out of that lawsuit. You can either spend resources you may not have trying to defend that lawsuit, or you can come to some kind of arrangement with the SEC about how to settle that lawsuit. But in every single case, the SEC refuses to settle the lawsuit, refuses to let you out from under the enforcement action unless you agree never to question any of the allegations made against you. And that really allows the SEC to leverage its strongest claims in order to silence political speech about its weakest claims. If the SEC brings an action against you alleging that you have that you're Bernie Madoff and that you murder puppies and also that you made an error in filling out a form 2 years ago, if you actually made an error in filling out a form 2 years ago, that may be something where you're willing to admit liability. But the SEC will only let you admit liability if you consent to an agreement where you're never allowed to question whether you're Bernie Madoff. They sent out a press release saying you're Bernie Madoff, and if you want to say you're not, you cannot settle the case about the form error because you have to globally agree to a gag order. So really, our case in the SEC is about the government leveraging its prosecutorial discretion to extract your silence and your agreement to refrain from political speech, and doing so in a way where you really have no escape from that enforcement action, except to induce them to exercise their discretion, and they're going to trade their discretion, their prosecutorial discretion, for your First Amendment rights. Here, as the dissent points out, this is a financial transaction. Ms. Overby has a claim for a certain amount of damages. She could settle it for a certain amount of money without a gag order, or she could make even more money and settle it with a gag order and kind of sell her First Amendment rights. And I think there's a factual difficulty with that, in that, at least as alleged by the plaintiffs here, Baltimore demands one of these gag orders in every single case without reference to the amount of the settlement, which does make it a little more like our SEC case. If Baltimore had said, we'll settle this for $50,000 or we'll settle it for $150,000 if you'll sign this non-disparagement clause, that looks a little more like the arm's length transaction the dissent is characterizing it as. But what you see, at least in the complaint, and this went up, it's technically a motion for summary judgment, but on the plaintiff's side, it really seems to be just on the pleadings. What they say is every single police misconduct case settles with a non-disparagement clause, which starts to make it look less like something that's being negotiated for and more like a cookie cutter, we will not release $1 unless you agree to trade your First Amendment rights, which is a more difficult place for the government to be in.
Although now that this case has happened and been argued at an argument in which perhaps the government didn't look so good, Baltimore has said that it's going to stop. It's represented at argument that it's going to stop engaging in this policy. I suspect somehow law enforcement in Baltimore will be able to keep functioning.
And with that, let's move on to the next case, which comes out of the 11th Circuit. Andrew?
Can I use this time to sing the entire score of Oklahoma?
Yes.
We'll do that in outtakes.
All right, so going to the 11th Circuit, we have a case of various atheist and secular humanist organizations against Brevard County, Florida, which is the county that's due east of Orlando in Florida on the Atlantic coast. And in that county, as in many various local governments and the federal government and all sorts of governments, meetings are opened with a prayer. This opinion looks at a 6-year period in which 195 prayers were given to open county council meetings. They were all monotheistic. And so local atheist and secular humanist groups demanded to be included in that.
So what's the outcome? Do they get to be included in that?
We don't know. The 11th Circuit decides it doesn't need to answer that question because of how illegally the county is behaving. So there is an unbroken streak going back to George Washington of just hundreds of years of this sort of legislative prayer. The Supreme Court looked at it in cases like Marsh v. Chambers, recently in a case called Town of Greece, and as a historical matter, it's fine. You are allowed to do this. It would take a lot to make it so that this sort of behavior is unconstitutional. And that's what the 11th Circuit finds. The 11th Circuit takes a look at the process that Brevard County is using to select its prayer givers and says, you know what? You have gone over the line. And they basically do that by looking at the depositions of the different county commissioners. There are 5 county commissioners who take turns. They just rotate, deciding whom they're going to pick to give the prayer. And 7, 2 former ones and the 5 current ones, were deposed in this lawsuit. And what they explain, basically, is that they're willing to keep out anyone who's in a minority religion. So they say things like, the invocation is for worshiping the God that created us, the one and only true God, the God of the Bible. They say things like, you need to look to a higher authority for spiritual guidance, which means you need to be a monotheistic type of person. You can't come if you don't represent the faith-based community of Brevard County. You can come only if you are part of a God-fearing religion. I guess is a common answer to anyone that's not a Jewish or Christian prayer giver. The attorneys deposing the commissioners said things like, would you accept a Muslim person? I guess. Would you accept a Wiccan? I guess. What about a polytheist? I'd have to think about it. I'm not sure what I would say. Only one of the 7 commissioners deposed said that as long as you were part of a church in the community, you would be allowed to come and give a prayer. 4 of the 7 said absolutely that certain religions were excluded. That included Rastafarianism, even though, as the 11th Circuit is at pains to point out, that is a monotheistic Abrahamic religion. Deists are out, so founding fathers like Thomas Jefferson and Ben Franklin wouldn't be allowed to speak. And after all of this, the 11th Circuit says, if there is one thing that is clear, it's that the process can't be discriminatory. This is discriminatory. You have to go back and formulate a totally new process. Are the atheists and secular humanists going to get included? We're not going to address that. The D.C. Circuit actually in a recent case said they don't have to be, but here what we do know is that the process is so unfair, you've got to do it all again.
And the thing that struck me about this opinion is the amount of time the panel spends sort of dissecting the various ways in which the commissioners are incorrect in their statements about religion. There was a person who at his deposition said he would allow a Hindu to speak, but he would not allow a representative of a polytheistic religion, when, of course, Hinduism is a polytheistic religion. There was the other who, as you referenced, said he would limit it strictly to monotheists and exclude Rastafarians, even though Rastafarianism is a monotheistic religion. And I think implicit in all of that, and the opinion doesn't come out and state it, but I think it does a good job of illustrating it, is that one of the reasons we forbid government officials from making theological distinctions is that government officials will tend to be extremely bad theologians, and that we should perhaps leave the theological niceties to actual religious leaders and not deputize someone whose primary expertise is in county zoning law to tell us which religions are true and which religions are false.
Yeah, reading this deposition testimony and listening to what these people had to say about how they exercise their solemn governmental duties, I mostly just cringed. I thought as a lawyer, I can't believe that these guys weren't prepped for deposition better. It just made me very uncomfortable seeing how poorly they did in deposition. I think as a broader takeaway, it's an interesting and sort of standard example of how Establishment Clause jurisprudence is evolving. Decades ago, the Supreme Court tried to formulate tests that could really be all-encompassing and work out whether any individual case of religious expression in public did or did not comport with the First Amendment. And now it seems like we're really moving to this sort of historical practice. This has been going on for a long time, so it's generally okay. Not those people, but in general, this sort of legislative prayer has been going on for a long time, and so that's probably enough to make it constitutional.
And with that, we'll move on to the final case, which comes out of the Second Circuit. Bob.
All right, so we are going to close up with Knight First Amendment Institute v. Donald J. Trump, President of the United States, in which the Second Circuit holds that Donald J. Trump's use of Twitter violates the First Amendment. And I like this case a lot because this case is something I changed my mind about, and it's really fun to change your mind. But I read about this case in the media when it was first filed, and I thought it was ridiculous. I thought the idea that the president violates the First Amendment by blocking people on Twitter was almost absurd on its face, that I couldn't understand how this was not a frivolous lawsuit. And then I read the parties' briefs because I thought, how in the world is the Knight Institute filing this case? And I read their briefs, and their briefs changed my mind, largely for reasons that show up in the Second Circuit's opinion. But I think so if the log line of the case, which is frankly what it's been in the media, if the log line is Donald Trump violates the First Amendment when he blocks you on Twitter, that sounds ridiculous. And there are a couple things that the panel does to clarify what we're talking about in this case that I think really makes clear what the First Amendment claims are. And first, the First Amendment claim is not actually your First Amendment right to spew invective at the president on Twitter. Instead, it's the consequences that flow from being blocked on Twitter. And it is hilarious that I am the person sitting here explaining Twitter to the two of you because I do not have a Twitter account and don't know how Twitter works. But I'll say hilariously false things, and then Andrew, who is a millennial, will correct me. But what happens is when someone tweets a tweet, that's the verb, you tweet a tweet. When someone tweets a tweet, others can tweet tweets responding to the tweet that was originally tweeted. And those tweets can then be seen by other people with Twitter accounts, and there amounts to what would have been a comment thread back in the days when people had blogs, that other people can see your tweet responding to the president's tweet, even if they don't follow you. And so that's a way to kind of broadcast your message to the people who see the president's tweet. And so it's not your First Amendment right to communicate directly with the president on Twitter. It's the fact that this forum of kind of being able to respond to tweets and be seen by other people is in fact a public forum where your speech isn't directed at Donald Trump. It's directed at the broader public in response to Donald Trump's tweets. And the other thing is that the case does not turn on the fact that Twitter is a private company. Twitter obviously is a private company. It is not bound by the First Amendment. It can allow users to block or not block whoever it wants. But the Second Circuit points out that the Donald J. Trump Twitter account is not necessarily created by Donald J. Trump, the private citizen. It is used for official announcements of his official governmental role. It is maintained in part by government employees on government employee time. And what the Second Circuit says is all of this working together combines to mean that it's actually a government-created account. And so what we have is a government-created forum on this private service where certain people are being forbidden from participating solely because they've expressed a negative opinion of the president. And general First Amendment principles say if the government creates a public forum and shuts people out based on their viewpoint, that violates the First Amendment. You can't exclude someone from public dialogue because he says mean things about the president or because he says nice things about the president. That if it's a government-created forum, then people have to be given equal access without viewpoint-based discrimination. And so even though Twitter is a private company, the government is using the resources of that private company to create a public forum, which is the same thing as would happen if a local government rented out a private hall for a public event and created a public forum in that hall, even though it's private property. If the government is in control of it, the government is bound by the First Amendment and can't engage in viewpoint discrimination.
If someone shows up to that private hall that the government rented and rants and then gets dragged out by the police, they're facing real consequences in the real world, possibly criminal charges. Is there anything like that going on in this case, like beyond simply being blocked? Like you're not facing criminal liability for not being able to tweet at the president's followers. That's
absolutely right. I guess you're in Twitter jail, perhaps, but you're not in real jail. They don't drag you anywhere. But you are being forbidden the opportunity to broadcast your thoughts. And so really the analogy is less the local government having a big meeting in a hall, but the government creating a bulletin board. If the government created a giant bulletin board in the center of town and said, this bulletin board is for everyone to post their thoughts so everyone in the community can see what you think except you, John, because you voted for the other guy, that would violate the First Amendment. That's creating a public forum where I'm just excluding you because you personally have bad ideas, which you do. But as the government, I can't punish you for your bad ideas. I can't exclude you from this opportunity everyone else has to broadcast their ideas to their neighbors. And that analogy holds whether the government builds the billboard itself in a public park or whether the government goes to a private landowner and rents his billboard. Says, hey, you have a great billboard there, Andrew. We'll give you $1,000 to let us lease it for a year so we can use it as this public forum that John's going to be excluded from for his bad opinions. And so there's a lot going on in this opinion about Twitter as a public, as a private entity, and about sort of the value of being able to reply to tweets in the first place that was not immediately obvious to me. But kind of drilling down into the arguments, it does seem like, to the extent the panel is right that the Donald J. Trump Twitter account is a government account maintained by government employees doing their governmental duties while they do it, it really is analogous to the government building a public billboard on Twitter and making it open to everyone except people who have criticized the president. And that actually does create a First Amendment problem.
It's a really nice application of, you see this a lot in the Fourth Amendment, of how we've got these principles. They are good principles. How do we apply them to a new technology, a new circumstance? And I think the Second Circuit, we're 3 for 3 today. We have 3 good First Amendment rulings. The Second Circuit really did it right. Any one person who can't be in the comments to a Trump tweet and can't say with a mix of lowercase and capital letters, Trump sucks or something, that one little loss might be not the most important thing, but you aggregate this up and you have a real principle that people should be allowed to engage in public discourse about matters of public importance, and that's ultimately what the Second Circuit is ratifying here.
And the interesting thing is going to be, assuming this doesn't go up for further review, is the downstream effects of this. Now that everyone but me has a Twitter account in the universe, I think there are going to be real questions of what's a private Twitter account, what becomes a governmental Twitter account. Obviously, when you're a candidate for office, it's your private Twitter account, but you still own it when you become a government official, and kind of what level of mixture of government policy and private tweets that you tweet will convert it into a governmental forum. And the opinion doesn't do a lot to give us guideposts on kind of when that alchemy happens. It seems like there has to be such a thing as an official government Twitter account. If, the city of Roanoke, Virginia creates the city of Roanoke, Virginia Twitter account, that's a government-created forum. But a politician who has a private account that they then use in their official capacity is going to lead to a lot of factually murky situations, which could well result in essentially every single member of Congress being embroiled in a First Amendment lawsuit about whether they're allowed to block the people who tell them they suck.
I could tell you one thing about the First Amendment that's clear after this, which is that the tweets of individual Twitter users are not government speech, which I'm bringing up because, as I explained, really bad legal arguments are of a lot of interest to me. And this is one of the government's defenses, which is that, just the entire thing is government speech. Donald Trump's account is official government speech. So just all of it is, the whole thing. And the Second Circuit very correctly points out that no, all the stuff that individual people said in response to that is their own speech, which of course it is. And in fact, I don't think the people defending the administration would at all say it is the position of the administration is what its critics were saying, which doesn't make any sense.
I mean, in fairness to the government, I think what underpins the government's argument there is that they don't understand what the government speech doctrine means, and I will concede that neither do I, and neither do you, and anyone who says otherwise is probably lying. So I guess they had to shoot their shot there.
It's interesting to me that you praise this opinion because it is indeed murky. which officials' Twitter's accounts will now become subject to this. It's kind of murky. Is it only the president? Is it elected officials? Is it appointed officials? There's all these lines that need to be drawn. And as you mentioned, there's murky factual questions. That's not usually, usually we look for clarity, right?
Well, I think there are certainly things that are going to have to be hashed out, and part of that is just that Twitter is a new technology. I guess not that new a technology anymore to people who listen to podcasts, but is a young technology, and we have to figure out a way to apply these old principles to new technologies and to new scenarios. And I think this opinion does a decently good job of doing that and of clarifying exactly what they're doing. The opinion's very clear that they're not deciding that Twitter itself is bound by the First Amendment. They're not making any sweeping pronouncements about the technology. They're trying to do what courts are supposed to do, which is look at the case in front of them and apply legal principles to them as correctly as they can. And for all that it leaves some uncertainty, I do think that for government employees who are worried about falling into the murky zone, there are certainly things you can do to make very clear that what you have is a private account. You can label your account your private account. You cannot use your account to make formal pronouncements of government policy within your realm of authority. You cannot have government employees maintain your account while you're on the clock. All of these are factors that tend to show the account is actually a government-maintained forum instead of a private forum.
Like if the National Archives decides that your account needs to be archived as official government material.
That might be a clue. And so all of these are, it's a multi-factor test, and so there aren't clear lines, and there's going to be litigation sort of hashing out exactly what is a government account and what is a private account. But there are also, if people are genuinely worried about maintaining the ability to block Andrew Ward on Twitter, as all of you should, there are things you can do to make abundantly clear that you're acting in your private capacity. And in that sense, extending this to Twitter is no different from having to extend these principles to kind of everyday life in a small town. Small towns have a mayor, and the mayor, is not allowed to do certain things in his official capacity that he is absolutely allowed to do in his private capacity. The mayor doesn't have to talk to you. The mayor doesn't have to let you come onto his farm and tell him you don't like his cows. But at the same time, the mayor can't, when he's presiding over official government business, deprive you of the ability to speak that everyone else would have. And it's that same analysis being applied to the internet instead of somebody's farm talking about their cows. But those are fundamentally the lines you have to draw. If you want a First Amendment that binds the government, you have to sometimes have cases that are about deciding whether somebody's acting as the government.
Andrew?
It's a good time to say that the farmer and the cowhand should be friends, but I just wanted to...
There's never a good time to say that.
I just wanted to point out that circuit opinions don't always have lofty statements of principles as their conclusions. But this one, even though it's just about Twitter, it does. The Second Circuit ended its opinion talking about the national debate and saying this debate, as uncomfortable and as unpleasant as it frequently may be, is nonetheless a good thing. We remind the litigants and the public that if the First Amendment means anything, it means that the best response to disfavored speech on matters of public concern is more speech, not less. And I think 3 cheers for that.
Okay, well then, in my personal and professional capacity, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice's Center for Judicial Engagement, mustering you to get engaged.